This Merck product manager is about to set in motion an action that could lead to either an $80 million loss or a $125 million gain in marketing opportunities. It all depends on how well he understands the workings of the 1984 ANDA Patent Term Restoration Act. Question: should the product manager recommend that Merck license in this compound?
I say take it. Under the ANDA Patent Term Restoration Act of 1984, a full NDA approval of a new chemical entity would net you an extra 5 years of marketing exclusivity starting from the day the NDA approval is official. You get 5 years even though the patent expires before that. Also, depending on the length of the regulatory review, we may get some additional patent life. If all the other marketing factors are right, I say take it.
In the next situation, the product manager has been asked to forecast the sales of a soon-to-be-introduced cardiovascular product, Mercure. The patent on Mercure was issued in 1984, and the product introduction is targeted for 1991. Gentlemen, Mercure will have a market penetration equivalent to accepted models. Question: when can we expect generic competition?
Wait a minute. Under the ANDA Patent Term Restoration Law, we can recover some of the patent life lost during the governmental approval process. Based on the length of the review process and the original patent term, our patent department should be able to get added patent protection for Mercure. Let's assume that generic manufacturers obtain approvals that become effective immediately upon patent expiration. If we didn't obtain any patent extension, generic products would probably be available in 2001. However, because of the available patent term extension, we can expect generic competition not in 2001, but in the year 2005. That's an extra 4 years of protection for us.
Here's another situation. You have the same product, Mercure, that was patented in 1984 for cardiovascular uses. In 1987, Merck obtained a patent for a different product containing the same compound, under the name Opticure. Question: do you get a similar patent term restoration for Opticure? Gentlemen.
For it fast.
No, you can't get an extension on your Opticure patent. You get extension of term only on the patent for the new chemical entity, and that was the compound covered in the Mercure patent. That means Opticure is covered until 2005 when the Mercure patent expires. Washington won't give you one more day on the Opticure patent. Therefore, an application for the extension of the Opticure patent won't be accepted.
Here's one of the most common questions product managers encounter. Question: what can be done to maintain the sales within the class within the limits of the law? Gentlemen.
Not if it was a product that was patented before 1984. Once a product is patented, we get only 17 years of patent protection unless the patent is eligible for patent term restoration. But products approved before 1984 are not eligible to have their patents extended. Any new patented forms will only protect those forms and will not affect the original products. We should look into the possibility of developing new indications of the older products in a new dosage form or strength. While a new patentable formulation will protect that formulation, not all new formulations are patentable. Again, we will need to include new clinical studies other than bioavailability in a new NDA. In this case, we can get some marketing exclusivity.
As you can see, this 1984 ANDA Patent Term Restoration Law is complex. You have some homework to do.